Hi, hello everyone. Welcome to the channel. I'm Cheryl and this is True Crime and Other Stuff. Thanks for being here, where I like to bring you the facts about true crime, the missing, current events, or anything I find interesting or important. Today, we're going to talk about Brian Kohlberger and the Idaho 4 case.
Four first-degree murder charges as well as a burglary charge. We know a lot of the evidence against Kohlberger, the cell phone data, the surveillance footage, his car, a match to DNA found at the crime scene, a potential eyewitness ID from a survivor in that.
Today, we're going to see what's going on in the courtroom. At a recent hearing for Idaho student murder suspect Brian Kohlberger, Idaho County District Court Judge John Judge urged the media and other courtroom spectators to have some dignity and some restraint, while stating he was not going to ban cameras from the proceedings. Well, that's pretty good news. I like cameras in the courtroom.
You're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint.
And the defense for Brian Kohlberger wants the indictment thrown out. They claim the grand jury were given the wrong instructions. Can you imagine that? The argument boils down to the defense team challenging the way in which the state decided to obtain the indictment, and the concept of the grand jury being able to find proof beyond reasonable doubt. But in the end, Judge denied the motion. Let's take a look at what happened in court.
And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue. What warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what it meant. And so I'm now put in a position of trying to explain why that occurred and why, in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, but nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, the Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it, and they said, no, you're wrong, it's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones. What it's intended to do is just make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. Obviously, we've been talking a bit about how we don't think that that's what occurred in this particular case. And we certainly don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause is the standard and what do people do it.
You probably should
cut at what the grand jurors did or didn't do.
That.
So in Edmondson, the Supreme Court said, and I quote, "The purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports the finding of probable cause, it is not for an appellate court to set aside the indictment." This court is bound by that holding. The Idaho Supreme Court applied that holding in 2 subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings.
To just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years.
I'm taking a fight at it.
And you may have the opportunity to do that to the Supreme Court.
Well,
I mean, that's what you're
And
building.
if
That's what you're building for.
if
Because you know that I am constrained by existing law. I can't just change the law as a trial court. I appreciate the argument. I think it's really creative. I am going to deny that argument. I think the argument is good, but I can't go that far. Not today.